This is Misdirection online. I'm taking the principle of law and taxation. Yes, based on the outline here, we are going to discuss, for chapter 1, we are going to discuss the nature of the company in chapter 1. Then chapter 2, the formation of the company. The chapter 3 is going to be promoters, while chapter 4 is going to be the board of directors. And chapter 5 is history and the legal background of the taxation in Nigeria. So then chapter number 6 is administration of income tax law in Nigeria. And chapter number 7, estate, trust, and settlement. While the last chapter is going to be the petroleum profit tax and the value added tax. Now, let us start from the nature of the company. Now, when we say company, what does that mean? Company can be defined as an association of persons aims together in carrying on a business within the view of making profit and sharing of the said profit. So it is not all the cases that all the companies are formed to make profit, of course, because we still have some companies that are registered as a charitable company, either by an individual or the corporate body as well. And in a legal sense, a company has been defined as an artificial person or legal entity that created by or under the authority of the law of a state or nation. This consists of the association of numerous individuals that an individual who subsists as a body politics under a special name. That is, two or more people can come together with the aim of establishing a particular company. And this company is different from a business organization in some cases based on the way they were all formed. So we have distinctions between the company and other business organizations. In the basic sense, the distinction between the companies in the legal theory and other form of business association is the fact that incorporations and registrations, the difference between the companies and other business organizations is just that of incorporations or registration with Corporate Affairs Commission, because there is what we call Corporate Affairs Commission. It's an agency of government that is shadowed with the responsibility of registering a company in Nigeria here before it has to start the operations. However, on the incorporation, as I was saying, the company becomes distinct but artificial person. The moment a company is being registered by Corporate Affairs Commission, it becomes an artificial person. Artificial person means he can sue and be sued. And the company then begins to have some rights and is subject to some liabilities and disabilities or duties just as human being. So there is no way a company will be registered. Once it is registered, it has an opportunity to sue anybody that crosses their boundary against them. And at the same time, they can be sued if they also do or involve in what they're supposed not to involve according to the law, because of because of their distinct artificial personalities. A company is capable of owning a property. So now, as an artificial personalities, any company that is registered by Corporate Affairs Commission, a certificate of ownership of incorporation will be given to them, issued to them. In that case, it is that certificate that will now qualify them to own the property and to sue and be sued in its name, among other things. And just as human being, incorporation then means, among other things, that the person dealing with the companies must also look towards that company and not its member for the performance of its objectives. Now, let me take this one for example. Like somebody happened to be a teller in the UBA as a bank. UBA is an incorporated bank, is a incorporated company. But somebody working as a teller there is just a staff there. So if a staff misbehave, it is not the personalities of that staff that misbehave to that customer, but it is the person is now representing the UBA as a whole. Now, what are the significance of the corporate personalities? Corporate personalities is the most pervading of the fundamental principle of the company law, because it's translated into a simpler form. It means that on incorporations, the company becomes a legal entity that is which is distinct from the members, that is the people that owns them, like two or more people that combine their resources together to form that business. So the company, as it is registered and with its name, they has their what? They has their own name to be protected apart from the name of the owner. So this concept is a creation of fiction, which in itself is one of the greatest devices of the law, through which men fit new legal norms into old principle as to deregulate conduct without abandoning long-standing principle. Now, having explained that, we still have um, some advantages of incorporations. What are those advantages? That if a company is being incorporated or registered by Corporate Affairs Commission, what are the advantages that is available for them? Yes, some consequences flow from incorporation, and the most important of these is the legal personalities that is bestowed on the companies, from which other consequences are or advantages flow. Number one, limited liabilities of the shareholders. So when an obligations are incurred on behalf of incorporated company, the company is directly liable, although it may therefore be able to obtain a contribution from its members or shareholders. And this is in the case with some modern public corporations. So in the case of the company registered under the Companies and Allied Matters Act of 1990, there is no complete absorption from the liabilities. So that is under the limited liabilities of the shareholders. And at the same time, there is property, what we call property. The property of incorporated associations belongs to it and not to its member. So if, like JPTS now, is a company as it is registered by Corporate Affairs Commission, so whatever it is owned by JPTS, it is not owned by Dr. Chris Imumelo. So in that case, it does not own such property as a trustee or as an agent of its member. So who in turn have no proprietary interest in the of the company. And legal right and be sued for breaching of its legal duties. So that body continues in existence and may exist perpetually in the of a change in its membership. So the membership of if the member of the company in one way or the other decided to leave or to exit from being a member of the company, yes, that does not mean the company is that is the end of the company. No. But when we are talking of this, the shares of the person existing from that company can be transferred by the person. So a company and a name are incorporated whose member has to come on behalf of the associations. Like since the incorporation is not able to validate. Yes. Okay. Yes, as I was saying, the point number 5 is borrowing. An incorporated company may borrow the money in its name, in its own name, unlike unincorporated body that whose members has to borrow money on behalf of the association. So since the incorporated body is more able to on his asset. Now, the other one is the transfer of the shares. Yes, membership of the company, the membership of the company, the membership of the company may depend on the ownership of the shares in it. So these shares are generally freely transferable in the absence of any express provision to the contrary. Like the case of private incorporated company, where the members must not transfer shares to members of the public. But where shares are transferred, the transferal of the shares is released from the further liabilities on the shares, which the transferee assumes. Eh? And a partners in the partnership also has the proprietary interest, which he may transfer, but the transfer does not operate to the vesting of his status or liabilities as a partner. Now, the next one is lifting the veil of incorporations. Yes, there are some conditions that may allow or warrant the legal means to be taken against the registered company. So that is the concept of the corporate personalities. So as earlier stated, so which endow the incorporated business associations with a distinct legal personalities. However, so there are circumstances in which the court would disregard and as often disregards uh, the company's personalities. Eh? In this regard, we discover that uh, there are some cases here because of our time, which I would like you people to read on your own. So that is on the then we have misdirection of the company. Misdirection of the company. So the corporation will be lifted in case of an individual company and in holding subsidiary relationship. So in the case of an individual or single company, the veil of incorporation will be lifted based on the case law precedent and the provision of the Company and Allied Matters Act or decree. The following instances has been identified. One, where a complaint has been formed to evade the legal obligations, yes, the law can be taken against them. Sometimes a crook may form a company and transfer his properties to the company to avoid personal legal obligations. So, following the principle of the corporate personalities, the transferred property should ordinarily belongs to the company, but the law, in the interest of the justice, would disregard the personalities of the company in order to subject the unscrupulous promoters to the obligations he has tried to evade. And at the same time, the next one is determination of the residence. Of course, this could also means determination of the character of the company. So a company as a legal person is expected to have a residence, and same goes to its member. So, but okay, let me a bit take you back to when where I started from. Part of the document that has to be submitted to the Corporate Affairs Commission before a company could be registered is the address of the directors and the address of that company. So in that case, determination of the residence. In this case, a company as a legal person is expected to have a residence, and same goes for its members. So determination of residence occur mostly in the case of multinational and transactional company, and the court may go further to examine the character of the persons, the character of the persons constituting the companies and the member of the company. So in that case, the company controlled by e.g. be treated as residents of the company. So you see a decided case there, of Daimler's and Co. versus Continental Tires and Rubber Company in 1916. So you can go through it. So then number 3 aspect of it is misdirection of the company. The major aims of incorporations is to give an adequate warning of the nature of the incorporated company. See the section 631 of Company and Allied Matters Decree of 1990, that the names of the companies must be fully and properly published on all the documents published by it. For instance, now the word limited, LTD, or limited must appear in the front of the name of a private company whose liability is limited by shares. So a failure to do so may, among other things, place on the responsible holder of the company, and the liabilities will have borne. Where, for instance, that the officer shall be made personally liable if the company refuses to pay. Such was the situation of four. Carry on the business with members and legal minimum. Yes, minimum of 2 members for a company. So like 2 people can come to that company and section 18 of Complaints and Other Matters Decree. But when you now look at the section 83 of the decree as well, they place abilities for it on or the officers of the company where the business of the company is conducted with less than minimum prescribed membership, and the business is so conducted for more than 6 months. So it provides that